All right, now are we ready for item F?
Yes, sir. Yes, sir. Sorry. This is just a short explanation of Georgia versus publicresource.org. Mr. Anders Gonton with Lexis, been working with obviously Lexis and following the case closely, and I asked him if he would to give kind of a short presentation to the commission on that and what effect, if any, it has on the Arkansas Code of 1987 and annotated.
Okay, he's recognized for the presentation.
Thank you. Good afternoon, Mr. Chairman, members. So I will keep this fairly brief, but I certainly will be happy to entertain questions afterwards. So earlier this spring, the Supreme Court ruled in the case Georgia versus the publicresource.org, which had to do with the status of the official code of Georgia, the copyrightability of that one. Georgia's copyright was challenged by an entity out in California. I believe that Arkansas also joined in with an amicus brief. Ultimately, the court ruled, and it's the ruling is, as these things often aren't, is particularly straightforward. Long story short, I mean, the public resource declared victory in terms of the copyrightability of the annotations. What we kind of found in our analysis, though, is that at this time, our estimation is that the ruling of the Supreme Court had particularly broad application. And one of the reasons why I'm saying that is that Georgia, the way that they do their codification work and their code work, differs from any other state. So mechanically, the work that we do with the state of Georgia is fairly similar to what we do with the state of Arkansas. One big difference is that there is a section at the beginning somewhere in the Code of Georgia that says that explicitly says that the annotations are merged in with the rest of the legislative text. Moreover, at the end of each annual legislative cycle next year, there is a vote by the full legislature to formally adopt the official Code of Georgia annotated. So because they're doing that in that specific way, and they specifically adopt the annotations legislatively, the Supreme Court kind of ended up with the conclusion that everything is essentially an edict of government and as such not copyrightable. No other state really does it that way. So at this time, I mean, our point of view, as far as LexisNexis is concerned, is that the ruling and its implications, until, you know, as these things go, right, until it's tried otherwise, we kind of feel that the application is limited to Georgia. I mean, it did affirm some important principles. I mean, certainly everybody agrees that the text of the legislation itself or the code is not copyrightable. You know, that there was a time when people used to think that certainly has been clarified as not to be the case. It also, which was an important point, it was that they affirmed that unlike works by the federal government that under the Copyright Act cannot be copyrighted at all, there is nothing that precludes or prevents a state government entity from copyrighting anything as long as it is not an edict of government. Certainly there were certainly things in the Supreme Court ruling with which I do not agree, and certainly some of the analysis that's not entirely apt. But overall, I mean, we feel that as much as we were disappointed in the outcome in some regards, at the end of the day, I mean, we do not at this present time see it as a major threat to sort of the model that is working successfully in Arkansas. That's not to say that we may not come back in a year or at any point in the future and want to have a conversation to see if we need to do any changes to the contractual relationship as a result.
All right, any questions? So as I understand it, at this point, there's no action to be taken. It's just a report on the status of...
That's correct. Yes, sir.
Okay.
Is it? What was the holding in the case, I guess? I'm just behind on that, saying that the Georgia Code can't be sold or copyrighted. Is that? I haven't read it. I apologize. The case.
Mr. Gatton, can you want to answer that question? Did you hear that? what the exact holding was of Georgia.
Sorry, was there a question there? It is tough to hear the audio in the room at times.
Senator Bond, what happened in the case, and Vince can chime in with me to recall the facts, a company basically took the annotated code, put it on a flash drive, and started distributing it for free, which was in violation of the copyright in Georgia. So that ended up being litigated all the way to the Supreme Court. The party that had made the flash drives alleged that the code was uncopyrightable because it was in the public domain, basically. And the court, you know, generally agreed with them. You know, as Anders said, he's arguing that it's similar, you know, that it's different than what we do here. Some parts of that opinion are similar to what we do here. Perhaps there's, you know, more to evolve as it goes on. But the issue there was, you know, the party took it, basically, and the court said that that was ultimately permissible because it existed in the public domain.
I have a question. May I speak?
Sure, you're recognized.
I read the opinion and I cannot distinguish it. I didn't study it intently, but I thought it sounded just like our situation, where we do not have a copyright in the annotations, and that I thought it did apply to Arkansas, and I wanted to know if Vince had studied it and saw ramifications for us down the road, where we would not be able to have exclusive copyright in our annotations, and therefore others would be able to contract to do annotations.
That's kind of difficult to answer because of the Georgia case. The state of Arkansas owns the copyright to the Arkansas Code of 1987, annotated. One of the questions that they're trying to work around, resolve, was the copyrightability of the annotations
Right.
by the state. And the court went off on kind of a tangent with that that really doesn't make a lot of sense, except maybe to them, about the annotations. So what that will mean in the future, I don't know. The commission may end up having to discuss separating the annotations from the code itself, allowing the publisher to copyright the annotations with a contractual requirement to either pass that copyright on to the state should we, for whatever reason, go away from a publisher, or perhaps require them to transfer that over to a new publisher in that kind of situation.
I know it only applied to the annotations, but it seemed to me you could extrapolate that that we wouldn't be allowed to maintain a copyright in the code either.
The actual statute language, no. I don't know if anyone's argued in a long time about the copyrightability of the actual statute language. It really fell mostly on the annotations, and how it was in Georgia's case merged with the statute language and adopted as such by the Georgia legislature, which is what we do not do here.
Yeah, and if I could add, if I may, it's hard to raise your hand when you're in a Zoom meeting, but if I could just add 2 quick points. First of all, I mean, this will become clearer at probably the next 6 to 9 months, because under the contract, we do continuously register the copyrights in the pieces of the Arkansas Code that we produce. And at some point, the Copyright Office under Library of Congress is going to come back to us, and the idea is going to issue the cert or the certificate, or they're going to push back. And how they will react is anybody's guess. I mean, speaking from personal experience, I mean, typically the Copyright Office is running about a year behind on applications from time that we file them till we actually get a certificate back. And then the other part too is that there's a fair degree of inconsistency depending on who actually looks at the application. So it will be some time. I think at some point next year, we will have a clearer picture on how the Copyright Office actually would use this, because they are in some ways, they're the first sort of arbiter of all of this. I do think, as I said, that it may be advantageous to look at a model whereby we, the publisher, obviously we do the annotations today, where we copyright them, but where you do an arrangement such as Mr. Henderson was mentioning, or whether we at the same time execute a non-exclusive royalty-free license to the state so that they can use the annotations in perpetuity should somebody else become the publisher in the future.
To the extent Ms. Brownstein was asking how this affects Arkansas, you know, at a future meeting, you may want to, the Attorney General's office could come in and discuss that. We, as Mr. Ganton referenced, we had joined that suit and filed an amicus brief, I believe, in Georgia. So, you know, our Attorney General's office is familiar with the case and its holding and had an interest in it. So at the appropriate time, they might be able to offer insight on that. It's a complicated issue. Again, there's things in common. Our Code Revision Commission is very similar to what they have in Georgia. You know, it's just kind of an unsettled question there as to what the next step would look like if someone pursued it.
All right, any other questions or comments? If not, we'll move to item G.